Okay. Welcome, lady and four gentlemen. I'm Councillor Hugh Mason, Cabinet Member for Planning Policy and City Development. The usual housekeeping: if the continuous fire alarm sounds, don't use the lifts, meet in front of Queen Victoria's statue. And also, if you signed in, sign out. The meeting is being webcast to allow the public to attend remotely if they so wish, and welcome to you if you are there. Please be advised that the public seating area is not in view of the camera. Everyone will be speaking on camera. Yes. Yeah, I think we can finish the rest of these because they're all to do with a public who are not here. So we do the introductions around the table. First of all, the councillors.
Roman Dent, Councillor for Copner Ward.
Simon Bosher, Councillor for Drayton and Farlington.
Hugh Mason, I am the Chairman. I am the Councillor for St Jude Ward. The officers.
Ian Maguire, Assistant Director for Planning and Economic Growth.
Edward Hetman Stapleton, Team Leader Development Management.
Cara Martin from Democratic Services.
I have here the minutes of the meeting held on Thursday, the 1st of February 2024 at 10:30 p.m. in the Civic offices. If you have read them, are they acceptable? Yep, right. I shall sign those later for the record.
Sorry, Councillor Mason, we don't have minutes of that particular meeting. Which meeting are you referring to?
No, the usual practice is that we don't circulate the minutes with the packs, but they go online shortly after the meeting. So they went online in middle of February.
And also, it's not an item agenda on the.
No, but we bring them along to the next meeting for the Cabinet member to sign.
Okay.
Right. Hello, George. We have just been joined by Councillor George Fielding, who is a member for the Central Southsea Ward. That's it. I had to remember. Memory is going. Okay, so all members who should be here are here. Are there any declarations of interest? Nope. You have before you the local validation checklist, pages 3 to 16, and I would ask Mr. Maguire to introduce this, please.
Thank you. No long presentation, members. The local validation checklist is a administrative document describing both the national validation leads and indeed prescribing your own local document requirements to make valid planning applications to ensure sound decision making can be undertaken. They do require to be reviewed regularly. This is one such review. Key changes are summarised in paragraph 4.1 of the report, and I'm happy to take any questions.
Members, questions? Biodiversity net gain, how is this evaluated and who does that job?
There is a national metric for biodiversity net gain created by central government, or by Natural England more specifically. We have an ongoing agreement with ecologists employed by Hampshire County Council to undertake that assessment work for and on our own behalf. Our own planners do some of the assessment as part of it, but the technical assessments, both of the acceptability of the submissions made by applicants, who of course have to fill out the appropriate information, both of the existing biodiversity and proposed biodiversity plans to demonstrate that net gain under the metric, is undertaken by, say, qualified ecologists at Hampshire County Council.
Thank you. Councillor Boucher.
I do have one question, and I'm hoping I'm not going to open up to a war and peace answer here. Looking at parts of this, it talks in terms of the applicant having the burden of proof on them to supply evidence for various things. I would imagine that behind this document there is something else which details that sort of information.
Depends to what you refer. So no, there are no other published documents. There are some, as linked in here, some various documents around, specifically requirements for contaminated land, etc. But for burden of proof for evidence, that's usually associated with certificates of lawfulness, etc. And that'll be on a bespoke case-by-case basis.
Sorry, yeah, that's what I'm talking about. I just picked out this one, and it falls within the same thing that you were talking about. The burden of proof in an application for a certificate of lawful development lies firmly with the applicant, and therefore clear and precise information supported by sufficient evidence must be given. I'm guessing that behind that is something that you're actually looking for, that you would seek from the applicant to be able to grant that certificate, so to speak.
Yes, there's no document of this is what that evidence is, because everything will be on its own individual case. We obviously have a pre-application advice service which applicants can engage with, and one of the things you could do for a certificate of lawfulness for especially proposed use would be to engage that service, and we can identify, well, this is the information we would need from you, for example, and in that dialogue you could establish whether, if you're trying to prove a use, you're looking for tenancy agreements or council tax records. If you're trying to prove that something is permitted development, you'd be looking for drawings and schematics to show they meet the limitations and size requirements. So it will vary depending on what it is they're trying to certify.
Again, page 15, the health impact assessment. Could you expand a little on what is what are the major elements which you would be looking at in a health impact assessment? And it is only for large-scale applications. How large is large?
So the second half is the easy answer. Major applications, so 10 plus units for residential development, 1,000 plus square metres for commercial development. So they're quite small, large scale. The major definition of development is well established throughout various different administrative parts of the planning process, so it's used in this case as well. This isn't in fact a new requirement. We have this requirement now on major applications. I'm not sure it's enforced as well as it could be. Some pragmatism is introduced for the smaller scale majors, but obviously we're taking the opportunity to reaffirm our commitment to these basic information, and thus it's appearing in the updated list and would be enforced going forward on all new major planning applications. The health impact assessment is, there's some good guidance available nationally in the National Planning Policy Framework and associated guidance documents. It is proportionate to the nature of the scheme. So what we're looking for is the impact of the development onto those wider determinants of health. And it may well cross-reference other documents, air quality, for example, active transport, other issues that could go to public health issues, both for future users, residents, occupiers of the scheme, and for the community wherein a development would be imposed. So the exact contents will vary depending on the nature of the development coming forward. A large polluting development would be a very different health impact assessment from a residential development, where we'll be much more concerned about how they've ensured access to public health, whether that be NHS services, green spaces, etc. within the scheme, and you'd tailor your individual requirements. Again, pre-application inquiry can be of great assistance here with the individual scheme, and we'd obviously work with our public health colleagues both to help applicants put the right information into those assessments and then tailor any assessment and planning conditions arising from it.
Thank you. If there are no other questions, are there any objections to my approving this? No, in which case it stands as approved. We move on now to agenda item 4, which is the enforcement protocol. Mr. Chetwynd Stapleton, if you would introduce this, please.
Thank you, Councillor. Yes, so this is just an update on the current policy, which is, there was no date on the website. I'll ask my colleague here when it was introduced.
I think it was about 6 years ago off the top of my head. We can obviously look that up should you wish us to confirm it.
So the previous document was guidance for planning compliance, how we regulate development across the city, and has been available to download off the council's website since then. This new protocol is being introduced at this time because on the 25th of April this year, the government introduced some changes to the timescales of various enforcement actions through the Levelling Up and Regeneration Act commencement order that was came into force on that day. So essentially, whereas before there was there were 4 and 10-year time limits, 4 years for operational development, 10 years for everything else. As of the 25th of April, that is the 4-year limit has now been done away with, and it's now everything is done down to 10 years for any enforcement actions instigated after the 25th of April this year. For enforcement actions that have been ongoing prior to the 25th of April, then the previous rules still apply. The commencement order also increased the duration for temporary stop notices from 28 days, 4 weeks, to 56 days, 8 weeks, and also introduced a new power called enforcement warning notices, which allows local planning authorities to issue warning notices inviting the regularisation of the development that's happened without planning permission when it appears that it may stand a chance of gaining planning permission. So that's a new tool and should be quite useful. Further, there have been the commencement order has introduced a restriction on appeals against enforcement notices. 25th of April, Section 118 of the Regeneration Act came into effect and limits the circumstances in which an appeal against an enforcement notice can be brought on the ground that planning permission should be granted for the development. It's also giving Section 119 of the Regeneration Act is giving the Planning Inspectorate the ability to dismiss appeals against enforcement notices and certificates of lawfulness on the grounds of undue delay, and it has increased the range, the financial. It's increased the amount of money that can be charged for financial penalties for a range of planning enforcement offences. As I said, there are some transitional provisions in force. As I said, with regard to the time limit, the changes in the Regeneration Act do not apply where the operational development or change of use to a dwelling was substantially completed before the 25th of April 24. With regard to stop notices, this will not affect any temporary stop notice that has been issued and not withdrawn before the 25th of April. I'm not aware of any currently in Portsmouth. And similarly, with regard to the appeals, again, any appeals and such like lodged before the 25th of April, the new timescales don't apply. So really, the reasons for this report are it's just to update the current policy, which is a bit long in the tooth. Introduces the new legislation brought into play by the Levelling Up and Regeneration Act, and updates and sets out the priorities for enforcement action, which will inform decisions about when to take enforcement action, and hopefully provides greater certainty for all parties engaged in the development process. Thank you.
Thank you. Members, questions? Councillor Fielding.
Thank you, Councillor Mason. Just the officers, really. Do you believe that the refreshed protocol, the new protocol that we have, will have an improvement in terms of our ability to take enforcement on non-compliant development across the city?
So these are a fresh protocol, so there are a couple of new powers, a slightly larger fine, so these will all add as greater incentives for compliance, so it will improve our ability on that basis. Would it make a large step change? No, we still have 3 enforcement officers investigating and utilising available tools, so I don't see an enormous change, but yes, we will have one additional tool and stronger powers to ensure compliance with planning control. Well, we do now, whether we write it in the protocol or not, we are sharing it and making it more available, and thus, hopefully, if people are proactively reading council protocols, they'll be discouraged from breaching planning control when perhaps they might not have been as concerned about it.
If I could also add to that, Councillor, the appendix to the protocol does provide advice and guidance to members of the public, citizens of the city on how to report breaches of planning control.
Fine, thank you. Councillor Bosher.
Thank you very much, Councillor Mason. I've got a couple of things I just want to try and understand in the appendix. First one is 4.7, planning enforcement team does not investigate the following. Little point 3, use of signage or development on highways, pavements or grass verges, nesting private ownership, etc. Where a development chooses to put all of its building materials either in the road or on the verges and whatever, clearly that's not a function from your team, because that's what that clearly says there. What interaction do you have? And it says the Highways Authority, which in the case of most of it in Portsmouth will probably be PCC or COLAS. What interaction do you actually have with COLAS to ensure that that enforcement happens, or don't you at all?
Liaison with all departments. I mean, planning enforcement doesn't sit in its own sort of ivory tower, if you like. It's very much cross-service working with all relevant departments. You know, our officers work closely with building control, for example. They work very closely with highways colleagues, and you know, through highways colleagues, the COLAS PFI as well. So yeah.
If I may, to understand your question in terms of interaction to ensure it's carried out, the answer is none. No, we work closely with all the other teams, so if a report comes to us, we'd make sure they're aware of it, but we don't have any direction powers as the planning service over the Highway Authority or indeed their contractors through the PFI.
If I can, Hugh, I'll give 2 examples, and these are both in Drayton Farlington as it happens. The first is, we've got and you'll probably be well aware of it because it was very contentious, a big Churchill development happening on the Havant Road between Carmarthen Avenue and Penn Arth. I can never remember which way round they are. And as I understand it, one of the conditions there was that they were not to access the site from the side entrance in Penarth, only from the main Havant Road. And yet they've been frequently doing exactly that, and my inbox has been filling up. Would that be then something to report to COLAS as the Highways Authority, or to yourselves as a planning enforcement thing? And I'm guessing that probably depends on what's in the planning application conditions.
Indeed so I can't talk to specific, but yes, a breach of a planning control, even if the purpose of the planning condition is a highways purpose, can be reported and should be reported to the planning authority, and then we would be the one enforcing, if it was necessary, a breach of condition notice under the Town and Country Planning Act. The expediency of such notice would be we'd work closely with colleagues in the Highway Authority to identify how often it was happening, whether any mitigation had been put in place outside of the planning process to see if it was unsafe or safe to do so. But if any action was to be taken, it would be under the Town and Country Planning Act, most likely.
So just for my own sort of personal benefit then, in a scenario like that, and I'm getting residents coming to me and saying there is a problem here and it is creating a lot of angst and concern, best thing I can do is to send that angst and concern both to planning control and COLAS and let you guys fight out exactly who's going to deal with it.
Yeah, that's certainly one way. If it is unclear whether the problem is one or the other, send them to both. You can send them to either, so we talk to each other, so we can do it that way. One of the purposes of the protocol is to ensure members and others that are community leaders don't have to guess, and it should give you guidance within there of how to manage those questions. But as I say, if it's a breach of a planning condition, then the planning authority almost certainly are the ones best placed to deal with it. If it's an activity being undertaken on the highway outside of the development site, probably the Highway Authority are the best ones to deal with it, as is the example in little 3 there.
Yeah, and that, sorry, that was my second example, which I probably knew the answer to anyway, where we've got another house that's been undergoing major renovations in Drayton and Farlington, where they've been storing all their building materials on the verge, to the point where over the course of a year, the verge is actually at a lower level than the pavement now, which is where it's eroded away. That is nothing to do with your team. That is entirely to do with highways enforcing that.
Assuming the verge is part of the highway, and assuming there isn't a specific planning condition to manage issues about construction management, which in a single dwelling renovation would be very surprising. If there was, yes, inevitably that would be the Highway Authority to deal with.
No, I think I already knew the answer. It was the first one I was more interested in. The second question, if I may, Hugh, enforcement case reviews. This is on page 9 or 29, whichever numbering system you're looking at. 5.12. Where a breach is identified, a decision will be made if action should be taken. Planning enforcement is a discretionary function, and formal enforcement action will only be undertaken where it's expedient or proportional to do so. That says to me that you don't always take enforcement action. What is the decision-making process behind deciding whether to take enforcement action or not? Where is the metric about expedient and proportionality which makes that decision?
Much like planning applications, and members that have sat on the planning committee will have heard me say many times, it is a matter of fact and degree. So there isn't a metric that we can say this is 10% over acceptable, we will take action, this is 9%, we won't. It'll be assessed on its individual merits of whether, first of all, it is a breach of planning control, and even if it is, whether it's resulting in any harm. It's the harm we're looking to regularise, not just the mere fact that there is a breach. We have to identify harm to make it potentially expedient and proportionate to take action. It'll then be a judgment applied by the professional planning service as to whether or not there is sufficient harm to warrant taking any further formal action.
Okay, so just an example, just to clarify that. If you have a road where you've got a number of properties that have got rear dormers, let's say, so they're not facing the street scene, they're facing over the rear gardens. They're all of a similar size, so there's nothing massive, they're all of a similar size. Is it proportionate then if somebody puts in a dormer and they use, let's say, I'll call it a plastic cladding, but I think you know probably what I mean in that, as opposed to following the roof materials where others might already have plastic cladding on some of the others in the street. So there's no preset. Does that make sense, or is that being a bit woolly?
Yeah, it does make sense. And again, I would have to see the house would be the short answer. Yes, certainly the basic planning isn't based on a precedent system, because every house in the street has a dormer. That doesn't mean one more house can have a dormer. It would have to be judged on its own merits. All development has to be of high quality design. It may well be that one form of material was acceptable on house A and it's unacceptable on house B, because every house is a little bit different. However, in a scenario, to give you an alternative hypothetical, if every house was identical, a series of terrace houses built exactly at the same time with little, if any, modification to them out of therefore the same materials, and they had all had similar rear dormer window extensions of the same size, utilising the same material, then yes, I would be very surprised if one more in the middle of that line wanting to do the same would be expedient to take enforcement action. But I'd have to have that degree of homogeneity of circumstances to have that degree of confidence. It would be a matter of fact and degree in each case.
Yeah, because I guess if you look at it simplistically from the applicant's point of view, they might turn around and say, well, I want to put a plastic cladding, I call it that, I think you know what I mean, it's that sort of popular GRP type stuff that people use on my dormer, and I'm now being told I can't do that, but yet 2 doors down they've got exactly the same, and 1 door down they've got exactly the same. The resident is therefore confused as to why were they allowed, but I'm not. And that's probably something that I'm not a planning expert, that I would bump into on a regular basis, is to trying to explain that aspect of it.
And if I may, the question is flawed. Requiring enforcement action or not
Well,
isn't...
whether the question is flawed or not, Ian, it's a reasonable question for
No,
a
if I may
resident
just
to
clarify
ask.
the nature of the question, because that person wouldn't have been told they can't do it. That person would have been told you need enforcement, you need planning permission for it. So, you know, often when we talk about materials for rear dormers, the dormer itself is acceptable, but materials are not, and therefore you need planning permission. The judgment, that's unacceptable, you can't do it, that's the refusal of a planning application. It's not an enforcement matter, that's the council has resolved that it is causing harm. There'll be an officer's report and a reason for refusal that will quite clearly explain why, notwithstanding someone 2 doors down has got something they think is similar, is unacceptable. So as a member of the council, if someone says, I don't understand, you can do no more than take them to the planning report. So it's not an enforcement matter, it's a development management planning application matter. What would happen for the enforcement is someone would build a dormer window without planning permission. The enforcement team would go down and say, well, that needs planning permission, and thus you should either, if it's clearly unacceptable, and they'd be able to articulate that in an enforcement notice, remove it, or as Edward referred to earlier, we now have a new power, something we always did just by letter, but we now have an official power to write an enforcement warning notice, say actually this may well be acceptable, we therefore invite you to make a retrospective application to regularise it, i.e., you know, here's a large hint that we think this is acceptable, please formally make the application. But it's that application that actually makes the statement you can or cannot do it. Enforcement is discretionary. It's not a criminal offence to undertake development without plan permission, but it's clearly never acceptable to undertake development that requires plan permission without it, and thus you know, we would be advising them you should regularise it. Or if we've already gone one step further and looked at a scenario whether this is just entirely unacceptable, it's a front dormer window, it's you know not just GRP, it's bright pink and it's in the middle of a conservation area, look, you're not going to get plan permission for that, please take it off. We'd be serving a formal enforcement notice pretty quickly on that. So the question that the hypothetical in there, that's not what would happen. An enforcement notice would never, enforcement officer would never be saying, you've got that, you can't do that. They'd be either saying, here is a very clear reason why we feel you should have an enforcement notice served on you, or they will be saying, you do need plan permission for that and we'd invite you to regularise the matter, which is certainly an indication from professional officers that we think there is a reasonable likelihood that plan permission would be granted for the thing you've applied for.
Right. Thanks, Hugh. I think I've taken up enough.
Okay. Where you have serious breaches causing irreparable harm, that is priority A, on page 34, would you automatically issue a temporary stop notice? And the second part of the question is, at the end of the temporary period of a temporary stop notice, what action can you take to continue the prevention of development?
So would we automatically serve a temporary stop notice? No, we'd never automatically do anything. It would be a matter of fact and degree. It may well be a matter of confidence we have in voluntary compliance, for example, because you know we do work on a negotiated and voluntary cooperative position with most applicants. Most breaches of planning control are undertaken by accident. Most people aren't setting out to breach planning control, they've misunderstood the law, etc., and they will voluntarily comply. So you rarely need to serve stop notices. Stop notices and temporary stop notices, they have implications, not just costs for the council, but compensatory implications as well. So we only use them if we have to, if we look the person that's undertaking the work in the eye and say, actually, we don't think you are going to comply with our request to stop working, and you will do more irreparable harm, so thus we need to serve it. And so it will be very rare where in the couple of decades I've been doing this, I think I've served two stop notices, one temporary, one permanent stop notice. So it is unusual to have to resort to that. The purpose of that temporary period is so that we can serve a formal enforcement notice and resolve those matters, or indeed take other action as may be necessary, up to and including injunction to go to the High Court to get a prohibitory or mandatory injunction to prevent them doing further work or otherwise limit what it is they are doing. For the serious and most irreparable harm, in fact, that injunctive route is usually more beneficial, but the stop notice is something we don't have to go to court to. We can write in-house, get out there and give us that necessary time to seek the semi-permanent or indeed permanent resolution through other tools.
Other questions, members? Right. Would there be any objection from members to my approving the updated enforcement protocol? No. In which case I do that. That concludes the entertainment of the afternoon. Thank you very much for your attendance and participation, gentlemen.